नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां हम आपके लिए एक बार फिर से लेकर आए हैं एक नया लेसन।
We are going to do today is to finish our discussion on the remaining aspects, that is proof of foreign law, and then immediately jump to the next topic, that is domicile. So today we will start our discussion on domicile. That's the next module in your syllabus. Now, in the last lecture, and just to briefly sum up or to contextualize what we were doing, was that we were focusing on the different stages of a private international law dispute. Now, in terms of focusing on different stages of the private international law dispute, we started with something called jurisdiction, that whether court has jurisdiction or not. Once the issue of jurisdiction is satisfied, then of course we move to the next aspect, that is of what is the applicable law in the dispute at hand. Now, this question might sound very simple to you, but as we have seen in the previous lectures, that this question often turns out to be a complicated issue when a foreign element is involved in a dispute. Now, in a situation where a foreign element is involved, the question is not just in relation to identification of one law or the other. The problem is that how are we going to classify the issue? So the problem starts with much more fundamental questions. What is the issue all about? Whether it is a matrimonial matter, whether it is a contractual matter, whether it is say some other matter relating to tort. Now, to understand that, or to have a final viewpoint on that is important, because unless we understand the nature of the dispute, it would be difficult for us to identify which law we have to apply. So unless we understand whether it is a matter relating to succession to property or matrimonial matter, we won't be sure whether to apply, say, matrimonial law or succession to property law. It is for that reason that classification is important. We also saw that there might be certain disputes in which, apart from the main question, there could be some incidental question. Give me 1 minute. Now, there could also be incidental questions apart from the main question. That's another aspect. The third aspect which we tried to cover in the class was in relation to renvoi, that when we have identified the nature of the law, when everything has become so certain, then the issue is that how are we going to apply the foreign? Whether when we are referring to a foreign legal system by using our own private international law rules, whether we are referring to just the substantive laws of purely internal law of that particular country, or we are also referring to the private international law rules. That is what we were doing for the past 2 or 3 lectures, to understand different ideas of renvoi, single renvoi. We also try to look at the issue of transmission, and we also try to look at double renvoi. Now, yesterday, we moved one step ahead, and in terms of moving one step ahead, we were trying to sum up our discussion on different stages of a private international law dispute, and we are still stuck at the second stage, that is how to identify the applicable law. Now, once all these questions which we have covered is satisfied, then the issue which comes for discussion is about the proof of foreign law. To put it in other words, or to put it in simpler words, that an Indian court, for example, is supposed to apply a foreign law to decide the matter at hand. Whether an Indian judge is supposed to know all the laws which exist in the world, in any other part, in any other country, or whether the proof of foreign law is something which needs to be established by the parties, which needs to be established to the satisfaction of the judge, that this is what the foreign law seems to be, and this is the correct position on the issue, and therefore this law should be applied to solve the matter at hand? This is the question which we are concerned about today. Now, what we saw yesterday, that when it comes to the question of proof of law, there are certain positions in common law system. The first is that proof of foreign law, or to put it in more simpler sense as to what is the law, is considered a question of fact and not question of law. And by now, I'm sure most of you would have realized that we are moving from more general discussion about private international law to more specific discussion on private international law issues. So here, when we talk about proof of foreign law, we don't consider proof of foreign law as a question of law. Rather, we consider it as a question of fact. That's the first point which I wanted to mention. And yesterday, one of your classmates explained the difference between question of law and fact, and what are the differences in terms of how question of law is placed and how question of fact is placed. A logical corollary of this point, that proof of foreign law is considered as a question of fact, is that no knowledge of foreign law is to be imputed to the judge. The judge should know foreign law. No, that cannot be necessarily imputed. The second point which I mentioned yesterday in terms of talking about proof of foreign law, that once we consider it as a question of fact, then then the proof of foreign law is done through, say, expert evidence or by certain other means through which facts are established. Now, when I say expert evidence, it has a specific meaning. Of course, we all know in terms of how idea of expert evidence is placed in Indian Evidence Act, and we will reflect on it very briefly now once we cover these 4 points. And when we say other means, we are basically talking about, say, examining documents, looking at official publication of the country concerned, and then satisfy the judge that, you know what, this is the correct law on that particular point. Generally, in common law, it is believed that judges, and especially about English judges, it is said that they are reluctant about conducting their own inquiry on the authenticity of law. Although last year we were reading a case where we saw that an Indian court tried to interpret CPC of Sri Lanka. Of course, that can't be a general trend. That has to be an exception in terms of how court try to read a particular domestic law for foreign country and then apply it. The third point which I wanted to mention is that who can be an expert? Now, the first point was that proof of foreign law is a question of fact. If it is a question of fact, it means that judge has to be satisfied about it, and the satisfaction is achieved through either expert evidence or some other means. Now, once we say expert evidence, who could be expert evidence? This is point number 3. When we talk about expert evidence, the general argument which comes out of it is that academic experience is not a necessary criteria. So just because someone is academically qualified, or for example, someone has written books on a particular question, that does not necessarily make him expert evidence. What we have seen is that there are different terms, different aspects, or there are different factors which have been taken into account by the courts to decide whether someone is an expert evidence or not. So yesterday we saw some examples where a Roman Catholic bishop was considered as an expert to, say, reflect on matrimonial law of Rome. Similarly, we saw that a commissioner of stocks in Brussels was considered as an expert in London when it came to Belgium law on promissory notes. Similarly, we saw that a traffic police officer was considered as an expert on road traffic law in Canada. So all these aspects are important. So there is not one factor which helps define the expert evidence. An academic criteria is certainly not the necessary criteria. The fourth factor is that who has to really prove the foreign law? Now, as I mentioned yesterday, that the question of or the onus of proof of foreign law lies on the party which is relying on it. So the party which relies on the foreign law, that party has to prove that what is the foreign law in the question. Now, we ended our yesterday's class with a fundamental issue, and the fundamental issue was that what happens when the party, say, does not talk about the foreign law or does not invoke the foreign law, or for example, the party fails to satisfy the judge about the foreign law. In such a situation, the judge will presume that the foreign law is same as lex fori, that is the law of the forum, and apply the law of its own country to solve the matter at hand. So that's one of the aspects which you must remember to understand how common law is placed in terms of proof of foreign law. When it comes to India, very specifically, India follows this trajectory, what I just mentioned. There's hardly anything here which we say that no, India differs in that regard. It broadly follows all these aspects. Apart from that, the codification of some of these aspects can be found, or reflection of some of these aspects are to be found in Indian Evidence Act. Now, I will very briefly take you to different provisions of Indian Evidence Act to reflect on how, for example, question of fact is placed in relation to foreign law. I would request you to go to Section 45 of Indian Evidence Act. And Section 45 of Indian Evidence Act talks about opinions of experts. Now, at least those of you who are following the discussion could easily relate this particular provision to what I was just referring to. That was about expert evidence to prove the foreign law. Now look at, I'm sure if you have read Indian Evidence Act, I'm not sure if you have studied Indian Evidence Act as of now. If you have read it, then I'm sure you must have read this particular provision in a completely different way, without actually reflecting on how foreign law is placed or how it can be used in relation to private international law. आपने पढ़ा है Indian Evidence Act पहले? आपने ये पेपर कंप्लीट कर लिया है? Yes, sir. Oh, you have done it. You people are already experts then in Indian Evidence Act, I'm sure. Far more better than how I am placed, maybe. When it comes to Section 45, let's read this provision. Let's read the bare text. And it says that when the court has to form an opinion upon a point of foreign law or of science or art, or as to identity of handwriting or finger impressions, the opinions upon that point of persons specially skilled in such foreign law, science or art, or in questions as to identity of handwriting or finger impressions are relevant facts. Such persons are called experts. It is broadly a reflection of what I just mentioned in terms of experts being used to prove foreign law, or for example, experts being used for the court to form an opinion about a point of foreign law. So that can easily be done. That's one part of it. Now, one simple point which emerges out of it is that expert witness, the idea of expert witness is to be understood in a wide sense. And therefore, Section 45 does not really try to prescribe specific criteria which expert witness should have. It tries to put it in more general sense. It tries to say specially skilled in such foreign law. Now, it does not really talk about, say, academic qualification. It does not only talk about practical aspects. It gives discretion to court, to put it in more technical terms, wide discretion to courts to decide whether someone is an expert witness or not. That's point number one. Now, there are many provisions in Indian Evidence Act. Of course, less technical, I would say, where question of foreign law has been reflected on. Look at Section 38, for example. Section 38 talks about relevancy of statements as to any law contained in law books Now, it very simply reads as that when the court has to form an opinion as to a law of any country, any statement of such law contained in a book purporting to be printed or published under the authority of the government of such country and to contain any such law, and any report of a ruling of the courts of such country contained in a book purporting to be a report of such ruling is relevant. Now, it fundamentally talks about the relevancy of certain statements, and we say certain statements mostly a reflection of how law and law judgments are placed, which are contained in a law book. So, for example, if a foreign country publishes all its law as part of a journal, for example, many do that. I mean, there are specific Britain, United States, they specifically do that, where they identify certain coded numbers to all the laws. UK identifies, there's a particular term for that coding which I can't remember now. There's a particular term for all those coded laws. At least in international law, I know that it is UKTS. For municipal law, there's also something. UKTS means United Kingdom Treaty Series. But I can't remember, I can't recall the domestic law thing, either way. Now, so all those statements as to any law, whether in the form of a legislation or in the form of a judgment, which are contained in law books, should be considered as relevant for the court to form an opinion about that particular law of any country. To put it in very simple sense, or official publication of a foreign country containing its laws or law reports can be admitted as evidence. To put it in more simple sense for the purposes of our clarity. Similarly, as I said, there are quite a few provisions which reflect on foreign law and the proof of foreign law. Look at Section 76 for that matter. Section 76, particularly clause 4 and 6, would reflect on foreign law to a limited extent. Section 78 Yes, 78, sorry, not 76. Extremely sorry, I got confused with 78 clause 6. 78, please don't get confused. When we talk about section 78, it is about proof of other official documents. And clause 4 mentions that the acts of the executive or the proceedings of the legislature of a foreign country may be proved by journals published by their authority or commonly received in that country as such, or by a copy certified under the seal of the country or sovereign, or by a recognition thereof in some central acts. So it identifies the ways in which the proof of official documents of a foreign country can be established. Because this is on a very general reading, you will understand what it actually tries to convey. Similarly, with regard to other public documents of any other class in a foreign country, it can be proved by the original or by a copy certified by the legal keeper thereof. Every country might have a legal keeper of the original documents. At least this particular phenomena is prevalent in all the legal systems. At least, again, I mean, going to my experience in international law, I can say that in international law, this is known as depository function. Similarly, in different municipal legal systems, there is an original keeper or legal keeper of these documents. Similarly, with a certificate under the seal of the notary public or of an Indian consul or diplomatic agent that the copy is duly certified by the officer having legal custody. Now, all these aspects can be considered as relevant for proving the authenticity of official or public documents. These are just very simple explanation of how proof of foreign law can be established. I have a personal experience to share. This is a classmate of mine who was from one of the SAARC countries. He was studying with me at South Asian University, and for some reason he wanted to authenticate some UGC regulation in his own country that he has satisfied certain criteria. Now, for that, he had to go to his embassy to get it certified that whatever documents he has is an authentic document. Of course, it told us as to, it really revealed in terms of how all these aspects are done. So first the university certified it, then of course he had to go there to the embassy to get it certified again that yes, it is original. Many a times, and that you might find it very hilarious that some of my classmates who were from particular countries, they had to get an extra stamp on the back of their certificate just to authenticate their degrees, that these degrees are original. So when countries deal with the official documents of other countries, of course, it has to be done in a much more precise way. When Indian Evidence Act tries to do exactly the same. Now, you have another provision called Section 84 of Indian Evidence Act. Section 84 basically talks about presumptions as to the collection of laws and reports of decisions. And it says that the court shall presume the genuineness of every book purporting to be printed or published under the authority of the government of any country and to contain any of the laws of that country, and of every book purporting to contain reports of decisions of the courts of such country. So this is again maybe a reiteration of what we have already been doing, that if the public that how court is supposed to presume the genuineness of those documents which are published under the authority of the government of any country. That's one part of it. Again, the fundamental point which needs to be underlined here and subsequently is that court will generally, as a matter of principle, not interpret, or court will not examine the foreign laws on its own and say that this should be the law by, say, interpretation of a foreign statute. That is something which court does not get into. Courts confine themselves to considering foreign law as a question of fact only, and they don't really get into legal examination in terms of interpreting the law or examining the law in the foreign country and making substantive remarks about the foreign law. That is something which courts avoid. Again, just the last provision, because we can keep on doing it. My idea is just to highlight these provisions. That is Section 57. And Section 57, one of the clauses, I think it's clause 13. I think it broadly mentions that on all matters of, say, public history or literature or science or art, that court may resort for its aid to appropriate books or documents of reference. So, in so doing, again, what is reinforced is that these aspects are considered as question of fact in particular. And again, the point which I'm trying to maybe repeat again and again, that proof of foreign law is a question of fact, not as a question of law. This brings me to the last aspect, which I wanted to just briefly touch upon before I move to the issue of domicile. And this is exclusion of foreign law. The good part about this last aspect, and why I wanted to touch very briefly on this aspect, is because we are going to revisit these points again and again in multiple case laws. And any exercise of maybe detailing all these aspects would be futile, because we won't be able to read all the case laws falling within the category of these exclusions. So my idea over the next 2 or 3 minutes would be to just list down circumstances in which the application of foreign law would be excluded. Now, Cheshire puts it in more concrete sense.
Excuse me, sir. So the
Yes.
the last part that we just covered, clause 13 of section 57, so how is it related to international law? Isn't it domestic law? Because it says facts of which the court must take judicial notice. And
Yeah.
clause 13 says the rule of the road on land or at sea. So where is it referring to? Foreign lands. It is referring to domestic lands or foreign lands?
Right after clause 13, there is a sentence that in all these cases, and also on all matters of public history, literature, science or art, the court may resort for its aid to appropriate books or documents of reference.
दोस्तों, अगर आपको आज का लेसन पसंद आया हो तो वीडियो को लाइक करें, इसी के साथ अगर आपने अभी तक हमारा चैनल सब्सक्राइब नहीं किया है तो सब्सक्राइब के बटन पर क्लिक करिए और बेल आइकन दबाना ना भूलें, ताकि आपको एजुकेशन से रिलेटेड नए नए अपडेट्स मिलते रहें। और अधिक जानकारी पाने के लिए आप हमारे फेसबुक और इंस्टाग्राम पेज से भी जुड़ सकते हैं, जिसका लिंक डिस्क्रिप्शन बॉक्स में दिया गया है। धन्यवाद।